Good morning, everyone. Welcome to our first compliance seminar of the new year. I hope the new year is starting out well for everybody here. For those of you who don't know me, and I think based on today's attendees, most of you do, but just in case, my name is Ann Lavelle, and I am CTR's compliance specialist. And we do these seminars once a month, typically on the second Thursday of every month. This month, we've just added a second bonus compliance seminar because of some interesting stuff that's come out of the city of Pittsburgh and Allegheny County. So folks who have offices or employees in that area may want to tune in next week on the 18th at 11 to talk about those compliance issues that are relevant to Allegheny County and the city of Pittsburgh with respect to their leave laws. Prior to working with CTR, I was a partner in a large law firm, did management side labor and employment law. I retired from that to spend more time with my family after about 20 some years of doing that. And I knew CTR from that life long ago. And I always loved the educational component of presenting. And so these seminars are great to try to educate folks and just let you know what's out there. And today we're going to talk about federal agencies. So there are some rules and regulations that are either just in place or are on the horizon that you probably want to know about. Whether they impact you directly or not, it's worth knowing the landscape out there. And the way federal agency rulemaking goes is Congress will say to a federal agency, hey, Department of Labor, we want you to address whatever the issue is. And then the Department of Labor issues proposed regulations, they get public comments on it, and then they issue what's known as a final regulation after they, at least theoretically, review all the public comments, take those into account, and they come up with a final regulation. That's how all agencies work. I'm getting messages that people are waiting in the lobby for the seminar, so I'm letting them in. Also, if you have any questions as we go on, just feel free to put them in the Q&A, and I will try to get to everybody's question as we move through the seminar. All right, so with that in mind, that background in mind, let's talk about, this is our roadmap today. We're going to talk a little bit about the Federal Trade Commission, which as employers, you probably think, what does that have to do with me? But it does. We'll talk about the Department of Labor. They have been very busy implementing what are primarily employee-friendly changes. And then we'll talk about the Equal Employment Opportunity Commission. We record all these seminars and we put them on our website. So if you're looking for this and want to review something, here's the roadmap. You can find it, and you can find the seminar on our website. All right. Federal Trade Commission. You hear this, and you probably think this has something to do with, foreign trade or big companies. But this is actually going to impact a ton of employers because a lot of employers are very sensitive about their trade secrets and making sure their employees don't run off with their trade secret information. And oftentimes, at least historically, employers have used non-competes. And what is a non-compete? Just in case you're not familiar with it, a non-compete says essentially, I signed that when I start working for you. And it says that if I leave you for whatever reason, I won't go to one of your competitors for a certain amount of time, usually 6 to 12 months. And the idea is that, number one, that makes it really hard for me to leave you because most employees can't go without a paycheck for 6 to 12 months. And presumably, if I was valuable enough to have a non-compete with you, I must know some of your trade secrets and your customer lists. That's a big one. And how you do business and your pricing and all sorts of things like that. And so you don't want me to run with my book of business from company A to company B and start selling or doing whatever for that company based on the information I learned from company A. The problem with these non-competes is for a long time now, they have been disfavored by the courts as well as by many state legislatures. and they're tough to enforce, but nonetheless, employers tended to use them indiscriminately. So there's certain cases where you could say, yeah, I see where a non-compete is necessary. If the owner sells a business, you don't want them to go one block down the road, open up shop, and start selling whatever it is they were selling at the first successful business. But employers took these non-competes and didn't just use them in a situation like that or for their highest grossing salesperson or something like that. They used them for everybody in the company, from hairstylists to warehouse workers. You have to wonder what trade secrets the warehouse worker who's moving boxes around or installing widgets or whatever it is has. And then they would try to enforce them. And that's really what rubbed the courts and the legislatures wrong. And that's a real problem. And so as you kind of look at this, there was a pendulum where the employers took this and ran with it, and the courts are trying to reel it in. The legislatures were trying to reel it in, but they were unsuccessful in getting legislation passed that would prohibit this on a nationwide basis. And so they're sort of backdooring this, for lack of a better word. The orders to the FTC by the parties involved is essentially, hey, you address this. This is part of trade, is non-competes, because non-competes suppress wages, at least theoretically, because I can't just move from company to A to company B. I can't just start my own business, so it suppresses entrepreneurs. Maybe it suppresses innovation. And they certainly have been abused by some employers. And they're extremely expensive to enforce and defend. So in my prior life, when I did this type of work and we would sue an employee for breaching their non-compete, it was really expensive on both sides, the plaintiff and the defendant, to initiate this type of lawsuit and to defend it. But generally, employers have more resources than employees, so it was easier for the employers to do this. Some states have just said, no, we're prohibiting all non-competes. That's California. Oftentimes, California is seen as a leader in this. Interestingly, and I like to just point this out because attorneys are the ones who enforce these non-competes, but in our own professional code of ethics, we prohibit non-competes for attorneys. So a little ironic there. But again, we haven't been able to eliminate these on a national level via legislation. So the Federal Trade Commission has stepped in and proposed regulations that ban employers from imposing non-competes on their workers, which they view as a poor practice. They've taken the position that it's an unfair trade practice within their realm of jurisdiction. I'm sure there will be a legal challenge to that, but that's the position they're taking. Their statistics say that non-competes, if we eliminate them, will increase employee wages by more than $300 billion per year. Where does that money come from? Not sure, but that's their take on it, and will expand opportunities for 30 million workers. So these regulations came out about a year ago. They received so many public comments that they were supposed to implement the final regulation last year, take a vote on it to implement it, but they've delayed it until April of this year. Now, a lot of folks think that this will still come to pass in some way, shape, or form, but that is likely to occur in April. And what makes it even more interesting is not only will the FTC prohibit non-competes, it will nullify any non-compete that's currently in place. So you may have a valid contract, a valid employment contract with your employees right now, and it may not be an abusive one that says, hey, you're a top sales guy or gal, and we do not want you to run off and work with a competitor. That contract will become null and void, and you will have an affirmative obligation if these rules come to pass, which is likely, to actually tell all the folks who have non-competes with you that, hey, guess what? It's no longer enforced. You can go do what you want. So that's a burden on your shoulders to not only say, hey, the non-competes is not good anymore, but we're going to affirmatively tell everybody how they can go compete with us. What does this mean for employers? If you have business information that you want to protect, you need to clean up your practices, first of all. Even if this rule doesn't become finalized, you shouldn't have everybody in your organization signing a non-compete. There's no reason to have the receptionist sign one or the janitor or anything like that. But focus on what we know we'll be able to enforce in the long run. So that's non-solicitation agreements. Saying, hey, for a period after you leave, we don't care if you work for our competitor, but you can't solicit our clients for a certain period of time. Focus on your trade secrets and confidentiality provisions. What is confidential information? It is not all business information. It's a subset of that. If you're too broad in your brushstroke as to what's confidential information, you won't be able to enforce any confidentiality provisions. So you want to narrowly tailor that. For example, the best example I can give you of that is a lot of employers are like, oh, our client list is a trade secret. It's our confidential information. But then in their advertisements, whenever they're trying to solicit business, they're like, hey, we're such a great company. Did you know companies A, B, and C are our clients? Well, if you've just announced that to the world, then your client list may not be a trade secret anymore. So you need to narrow that down and figure out what truly is confidential information that you want to protect. And then invest in an intellectual property attorney if you have specific technology or trademarks or whatever it might be that you do not want to see somebody run off with. That takes some time to put trademarks or copyrights or whatever it might be in place, but now's a good time to look at that and say, if we haven't protected our intellectual property, we should, because that is one of your most valuable assets. You wouldn't operate your business without fire insurance for your building. You shouldn't be operating without protecting your intellectual property, even if this rule never gets finalized. And again, it looks like it will, but it's just smart business practice to protect your intellectual property with the legal options that are out there. Okay, moving along. And there we go. Okay. Department of Labor, this is an organization that I am sure all employers sitting here is more familiar with. The DOL, so it's the federal DOL. There's a state Department of Labor and Industry in Pennsylvania and in most states as well. And the issue of independent contractors has been one that when I practiced law, it made me want to pull my hair out. And I have a lot of hair, for those of you who have seen me. It's like a pendulum, this issue. And it depends which party is in office, how liberal or how narrow a view they take of who is an independent contractor. So right now, and I try to stay apolitical, but historically at least, when we have Democrats in office, they take a much more narrow view of who is an independent contractor. And the current view is that very few workers are independent contractors. And that should be a red flag for any company that has a lot of independent contractors in your workforce. There's different tests out there to determine who's an independent contractor. And we're going to talk about what the DOL is doing to try to make it more uniform and narrow the scope of who is an independent contractor. But right now we have a landscape where there's different legal tests out there to determine who's an independent contractor. But I always told clients, an independent contractor should look like the plumber who comes to my house. The plumber and I may agree on a day and time for him to show up. And I may tell him what the problem is. You know, my kitchen sink is broken. Please fix it. But I don't tell him how to do the job. I don't supply him with the tools. Trust me, I sure don't have the knowledge to fix any plumbing problem in my house. And I've proven that a number of times through the years. And when he's done with whatever he has fixed in my house, he's going to give me a bill and I'm going to pay it. And then he's going to move down the street to somebody else's house and work on their problem. I may have an ongoing relationship with a plumber where he comes every now and then, but he's not at my house every single day, thankfully. Wouldn't be able to afford it. The red flags to know if you're probably on the wrong side of the independent contractor situation. If the vast majority of your workers are independent contractors, that's a huge red flag for the DOL. I routinely saw in practice some really inappropriate things with independent contractors. For instance, an employer would say, hey, you're an independent contractor, Joe. Here's a non-compete to sign. Here's our employee handbook. Please sign off on it. What's the problem? My plumber a non-compete and tell them they can't work for the neighbor? No. Do you give them an employee handbook? The name of the handbook is employee handbook, right? Not independent contractor handbook. You start doing that, that's all inappropriate and really makes the worker look like an employee and not an independent contractor. If the person only works for one company, my plumber does not just work for me. Again, very thankful for that. He works for many, many, many people. If this person only works for you and no one else, that looks like an employee. If the worker has no investment in tools, location, education, etc., like they don't have their own business location, their own, that plumber is taking a risk. What if I don't pay him? He has an investment with his tools and his time and his education that if I am a bad actor and don't pay him, he's going to take a loss on it. He can also earn profit if he does a great job and I call him back, for my other plumbing needs. Has specifically said that, hey, just having a worker like a mechanic buy their own tools doesn't cut it. That's not what they're looking for, right? They're looking for a business, even if that's just a one-person sole proprietor business that has their own tools, their own business, their own specialty education that is typically different than what your company does, right? I don't do plumbing. But if I was a plumbing business and I had independent contractors who were plumbers, they're doing the same work as my business. That makes them look like they're not independent contractors. So this is a hot button item for the DOL. It has been for a while. They've made new regulations. We're going to talk about that in a second. But these are the red flags you should be looking for. And you should also know this is one of the worst parade of evils that you can get if you're on the wrong side of determining who is an independent contractor. So if you have messed this up and you have misclassified somebody as an independent contractor who really is an employee, you have tax issues, you have workers' comp issues because you haven't had them on your workers' comp. You're liable for employment claims, discrimination, harassment, whatever. You're subject to DOL wage and hour investigations or investigations into the correct classification of these individuals. Benefit claims. You didn't let them participate in the 401k. You didn't give them health insurance because they were supposedly an independent contractor when they really weren't. Wage claims, right? You didn't pay them overtime. You maybe didn't even pay them minimum wage or whatever it is. That is a long list of evils that flows from a misclassification here. So like I said, there's a number of tests that courts look at, and the DOL is trying to streamline those tests to make it more employee friendly. So the DOL has proposed or perhaps finalized, there's a little bit of gray area here as to what the DOL is doing because they said it was final, but they've got some legal challenges to it and whatever. But this is the test the DOL says it's now going by. And it's a 6-factor test. And so if you have independent contractors floating around, you should look at these folks and say, if I apply these 6 factors to my independent contractors, to each one of them, how does it look? So does the worker have an opportunity for profit or loss? And the DOL has made it crystal clear that simply working more hours, right, is not what they mean by the opportunity for more profit or loss. They mean, like the plumber, It can drum up more business if he does a good job at my house. Investments by the worker and the potential employer. You both may invest some effort in this relationship, but the worker should have some skin in the game, right? Their own tools, which isn't wholly determinative. Maybe they have their own vans and trucks, their own office, whatever it is, but we should see some monetary investment by the worker. The degree of permanence. My plumber, I'm hoping he's there for a shorter period of time as humanly possible to fix my whatever problem, because we're paying him by the hour. If you have an independent contractor who's working for you for months or weeks or years on end, that's not an independent contractor, or it's unlikely to be that. That looks more like some type of employment relationship because they're continually working for you. Now, you can have situations like an IT group that does your IT servicing, and you've had a relationship with them for some time, but they're not in your office every day. They're not, they're just like a help desk that gets called now and then. That's okay, because they have their own office, their own investment in technology, etc. The degree that you control their work, right? I have very little control over the plumber. He shows up at a mutually agreeable time and he fixes the project that I have pointed out. That's the extent of my control. If I'm handing out that employee handbook to my plumber, it's a problem. And I can't tell you the number of times that this issue came up when I practiced, that the employer was like, oh, yes, we hold them to a strict standard of conduct. We have them sign off on our employee handbook. And I would just want to hit my head off the wall, because as soon as you do that, it looks like an employment relationship. Same thing with non-competes, non-solicitations. Those sometimes can work, but you have to be really careful about how much control, how much of a standard of conduct or a standard of what they can and can't do you're controlling them by. Is the work they're doing basically the same that you do? Is it integral to your business? If it is, they're not an independent contractor. And of course, the worker's skill or initiative. So in my plumber's case, right, he has his own unique skill. I don't have it. I have no idea. I just break things. The worker should have their own skill, right? This should not be somebody that we just pulled off the street and we could have anybody do this job. That's really not what we're looking for. Again, there's legal challenges to this right now. So whether you want to consider this still a proposed or final rule, there are legal challenges, but the DOL has said this is the rule that it's using to analyze workers right now, despite the legal challenges. So know that if you have independent contractors, the legal landscape right now, the political landscape is very narrow as to who is an independent contractor. And this is the test that you're looking at with the DOL to determine if you have an independent contractor or not. Okay, again, if you have any questions or you're bored to tears, either one, say hello in the Q&A and we'll respond. I'm going to take a quick drink here. Okay, this is a big one as well. We covered this in a whole seminar when this first came out. DOL, the Department of Labor, is in charge of the Fair Labor Standards Act, which controls minimum wage and overtime payments and exemptions and all of that good stuff that probably gives every single person on this webinar a headache. I do recommend Advil for that. In any event, the proposed regulations came out last year, towards the end of the year. And basically it said, we're increasing what's known as the salary basis test. So to be exempt from the payment of overtime, an employee must meet both the duties test and the guaranteed salary basis test. The current salary basis is roughly $684 a week, which is about $35,000, a little over that each year. It must be paid on a weekly, or it must be a weekly $684 that they're receiving. The proposed regulations, which again came out last October, upped that amount to a little over $1,000 a week with a 3-year inflation metric. Right now, 1,059 a week is roughly 55,000 a year. However, these regulations are not finalized. So this weekly metric will keep growing until the DOL finalizes the regulations. Currently, the DOL is projecting that for the first quarter of this year, the weekly salary metric is roughly 1,158 a year, or 60,209 a year. So when we're looking at what we might have to pay folks in the future to keep them exempt, we have a bit of a moving target until the DOL finalizes these regulations, and then it will lock in the price tag, so to speak, of the weekly amount, and we'll be able to rely on that for the next 3 years until the inflationary metric raises it. I want to point out something as well. Some of you have heard of the highly compensated employee exemption, where if the worker earns a certain amount, right now it's a little over 107,000, and meets some minimal duties tests, you don't have to pay them overtime. That is going to be bumped to about almost 144,000 a year. And again, that number is a moving target too, because we won't know the exact amount until the regulations are finalized. I want to point out something that is really critical, because this came up with one of our clients the other day. Pennsylvania has its own wage and hour rules that do not perfectly align with the FLSA. So some of the exemptions that the FLSA recognizes, Pennsylvania does not. Pennsylvania, if you're sitting here and you're in Pennsylvania, and I know most of you are, does not recognize the HCE, the highly compensated employee exemption. It doesn't matter if you pay the person $1 million a year. If they don't meet for the administrative, professional, or executive exemptions, you're still paying them overtime. Pennsylvania does not recognize this exemption. It's worth saying that several times. You cannot use the HCE exemption in Pennsylvania. That's true with other things as well, and we've covered that in other seminars. Pennsylvania doesn't recognize the computer professional exemption. It doesn't recognize the 8 and 80 rule, for usually used for healthcare workers to determine overtime. Any of that is not recognized by Pennsylvania, and you will still owe overtime to the worker. But if you have employees in other states that do have laws that align with the FLSA, then you can use that HC exemption, but know that it's going to drastically jump when these rules are finalized. So where are we right at the moment? Public comments are being reviewed. Those people had until November to submit those. And the DOL is theoretically looking at those and analyzing them and deciding what it wants to do with those. But what should you do now? You should look at who falls into that gap in your workforce, who right now is considered exempt, but wouldn't be solely because of the salary basis test. Because right now, maybe they make $800 a week, but that falls short of the 1,059 or the almost 1,200, depending on where exactly that number lands. That's who you look at. And you need to look at the economic impact of how you're going to handle that. Does raising their salary make the most sense? Does paying overtime a legitimate option for them? Or do you hire more individuals? Some people, different employers will come out different ways on that. But that's what you need to be looking at, and you really should look at it now, because once these regulations are finalized, which is likely to happen in the next few months, there will be a legal challenge. There always is. That's what keeps us attorneys employed. Historically, the way these legal challenges have gone is that there's a very short window for employers to react to the court decision. So you need to be ready to pivot. So the regulations will be finalized. There'll be a legal challenge. We'll get some decision, which will be appealed, I'm sure. And we'll eventually get a final decision. And then, like the last time this happened, there was only a couple days for employers to react. You can't make these type of decisions in 72 hours. So you want to know how you're going to pivot, how you're going to handle that if the legal challenges go support these new regulations. And again, we did a whole seminar on this a few months ago, explaining why there would be legal challenges and why there's this inflationary metric and all that good stuff. So that is on our website if you want to delve into this issue even more. All right. Technology is not always my strong suit here. 1 second. I went too far. Give me 1 second here. Okay. The EEOC. This is also a agency that I am sure most of you are familiar with. We did a whole seminar on the Pregnant Workers Fairness Act when it came out, and the regulations, the proposed regulations when they came out. So in a nutshell, and you know, we could talk about this all morning, which I'm sure all of you would be anxious to do, but you want to essentially look at this and think about it in terms of the ADA. So for those of you who are interested in the Pregnant Workers Fairness Act and know it's going to apply to you, which is most of the employers on this webinar. And somebody just asked a question. I'm glad you asked. Will we get a copy of this webinar? Yes, we not only record it so that you can revisit all of this fun information, but the slides are made available too. So just give us a little bit of time after this ends, because it takes a little bit of time to have that recording come through and then publish it to our website. But yeah, absolutely, you'll get a copy of all this. It's great reading if you have insomnia. All right, so the EEOC passed the Pregnant Workers Fairness Act, which essentially said, hey, we have the ADA, the Americans with Disabilities Act, which protects people with long-term disabilities, but we have nothing in most states that protect pregnant folks who get complications. And now we do have it on a federal level. It's very similar to the ADA, but it's for the temporary conditions that come with pregnancy. Most of them are temporary. And it used to be the ADA didn't cover pregnancy because it was viewed as temporary. So that's why we have this law. I see we have another post here. 1 second. Yes, somebody asked, you have to have 15 employees for the PWFA. That's correct. It's just like the ADA. The ADA starts with 15 or more. I will point out, though, with respect to the ADA, and Pennsylvania hasn't come through one way or another on this with respect to the PWFA. But in Pennsylvania, we have a state law that mirrors the ADA and starts with 4 or more employees. So when I used to practice, and we're having a little sidebar here, we're off the PWFA topic for a second, but this is a great question. When I used to practice, employers would say, hey, I'm not covered by the ADA because I only have 12 employees. Technically, that's true, but you are covered by the Pennsylvania law that mirrors the Pennsylvania Human Relations Act, that mirrors the ADA, and it mirrors the obligations under there. So if you're a small employer with 4 or more employees, you still are subject to the PHRA, which puts the same burdens more or less on you that the ADA does. So little sidebar there on the ADA, just to make sure some of our smaller employers know that they are covered by state law that will impose the same ADA more or less burdens on them. But with respect to the PWFA, we are looking at 15 or more folks in a company. And the proposed regulations seek to define some of the terms that were in the law. So the law essentially said, hey, if the woman has a limitation, they're going to be covered by this. And the regulations essentially said it's a huge umbrella as to what a limitation is, right? It's a physical or mental condition arising out of pregnancy, childbirth, or related medical conditions. And we'll talk a minute about what related medical conditions can mean in this context. It can be a minor problem. It can be episodic, right? Maybe it's only morning sickness for the first 3 months. I wish I had only had morning sickness for the first 3 months, but we won't talk about my issues here. You know, that we're looking for conditions like that. So some things are obvious, right? Like the morning sickness. We know that that's related to pregnancy, but what are other related medical conditions? The court went on to say, if I can get my screen to move, Related medical conditions, and you can look at this and think about this. Lactation, right? Use of birth control. This law covers somebody who might need time off for something like that. I could see situations where the person is having, an IUD put in or something that might be covered by it. Menstruation. That's an interesting one to me that hasn't been fully fleshed out here. What if I just have bad periods every month? Is that covered? That's a bit of a question mark right at the moment. Other things that make perhaps more sense, like miscarriage or stillbirth. And of course, controversial issues like abortion is covered as well. The EEOC made a huge point of the fact that this list was not exhaustive. And the EEOC also has pages and pages and pages of examples that you can look at as to what they view a related condition might be and how you should handle it if you come up with that issue. The EEOC also views leaves of absence as generally meaning at least 40 weeks, right? That's the length of a pregnancy. And they're seeking comments on whether or not an additional 12 weeks is appropriate. And I know I have some questions. I will get to those in a second. I just don't want to lose my train of thought. So we may end up with final regulations. Right now, the EEOC is actively enforcing the PWFA based on these proposed regulations. We may end up with final regulations that actually say, hey, up to 52 weeks of time off, right? We got a year, is reasonable if you have complications that fall under this act. There's also an issue right now of how we count the need for intermittent leave or accommodations. I suspect that we will come out very much like we do with the ADA for intermittent leave, that we will look at it in the shortest time period that our timekeeping systems can allow. But that is a challenge for employers. It's always a challenge under the ADA. It will be a challenge under the PWFA as well. It might be easy to say, okay, Ann needs a doctor's appointment once a month, but what about if I have morning sickness and some days I feel great and some days I don't stroll in until noon because I've been so sick. And I'm certainly not trying to minimize morning sickness because that is, as somebody who experienced that firsthand, it's awful. But how do we count that? How do we look at that is one of the issues that they sought public comment on, and they're theoretically digesting right now as to how that should be handled. Okay, let me look at the question real quick here that we got. Okay, so this question's a good one. It says, if an organization is notified of a pregnancy and the employee is in a role of either working with chemicals, heavy lifting, or other physical activity, should the employee be approached and asked to take the job description to the physician and ask in advance for accommodations, or wait on the employee to come forward? So this has been an issue for a long time, even before the PWFA. And right or wrong, the way the courts have viewed this is the employer should not be paternalistic. There are very few exceptions to this, but you shouldn't be paternalistic. And I hate to say that because employers, I think when they have the situation, are acting out of the goodness of their hearts. They don't want the woman to get injured or have a problem. And they shouldn't be saying, hey, Ann, your job requires you to lift 50 pounds. We don't want the workers' comp injury. We don't want you to get hurt. We don't want the baby to get hurt, whatever it might be. That's not the view the courts take, that you should be doing that. The courts really, with very limited exceptions, like there's exceptions for flight attendants that are pregnant, different things like that. You really should not be saying, hey, employee, we don't think you're capable of doing this. We want a doctor to confirm that you are capable, unless there's been an incident in the workplace that gives rise to making you think that that person's not capable for some reason. So if the person comes forward and says, hey, I have a lifting restriction, right? I'm 8 months pregnant. I can only lift 10 pounds. Then, of course, you need to kick it into high gear and look at that restriction, whether you can accommodate that. And I think in most cases, the courts will say you should and can accommodate that. This is also a training issue. I often harp, I sound like a broken record, on first level supervisors because they tend to be the friends of their employees. And if Ann comes up to first level supervisor and says, gosh, my job is really tough and I'm just dying lifting these boxes, right? And I'm 6 months pregnant, then I think that has put the company on notice that I have an issue. And so your supervisors have to have enough knowledge about the law, especially your first level supervisors, to say, oh my goodness, Ann just said blah, 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 and I need to run it up the flagpole because somebody needs to deal with the fact that Ann has made this comment that she is having trouble lifting these boxes or needs to sit down or whatever it might be. Again, we did a whole seminar on this, and we do have that out there. Now, I see I have a chat question. Somebody cannot access the Q&A. If you can't access the Q&A for some reason, I'm not a technical guru and I have no idea why, but feel free to type your question in the chat section and I'll be sure to look at that too. I apologize if there's a glitch here. Okay, so hopefully that helps. These proposed regulations also say that an employer cannot require, and this kind of goes to one of the questions here, cannot make an employee accept an accommodation without having a discussion with them first, which makes sense. You can't deny a job or other employment opportunity to someone just because of their need for a reasonable accommodation under this law. And going to the one question that was asked long ago and far away before this law ever was out there, we had a client at the firm I worked with who, out of the goodness of their heart, was afraid to hire somebody as a housekeeper for a nursing home because the person was 3 months pregnant and they were worried about all the laundry and bedding and other stuff the person would have to lift. So they told the employee, hey, we won't hire you now, but after you have the baby, we'd love to hire you. That person went to the EEOC. That's pregnancy discrimination. So it doesn't matter if we have this law or the proposed regulations or not, even prior to this, you couldn't be paternalistic like that. Okay, you can't require, this is an important one, you can't require the employee to take leave if they could otherwise be accommodated in the job. Because we're not trying to take away a paycheck, right? So if Ann comes up to you and says, I can't lift the 50-pound boxes, you don't automatically say, well, Ann, we'll enjoy the last 6 weeks of your pregnancy, we'll put you on an unpaid leave and your job will be here when you have the baby. No. We look at whether or not we can keep me in the workforce by maybe making Joe or Sally or whoever lift those boxes for me and let me do the other portions of my job. That might be a reasonable accommodation. That is an individual determination that needs to be well documented with respect to each person. Of course, you can't retaliate or interfere with an individual's rights under the PWFA. That's true of all employment laws, so that shouldn't be a surprise. The one thing I want to point out, and we covered this in more detail in the webinar on this, is some requested accommodations don't require any doctor's note or proof. So if you have a pregnant person who says, I need frequent breaks to drink water, I need to have water at my workstation, I need to grab a snack, I need to have a seat if at all possible, the regulations basically say, hey, that's such an obvious need for somebody who's pregnant, you can't require them to submit medical evidence. So those of you who are familiar with the ADA, we always require medical evidence. That's just good employment practices when somebody requests an accommodation. A little different under the PWFA. For some accommodations, we can request medical evidence for the need for that accommodation. And for others, like I need a seat, no, we can't. We should be looking at that accommodation, and most times we should be able to make those accommodations except in extremely rare situations. Okay, moving on with the EEOC, because they're busy little bees, I guess. So this we've covered a little bit before, but it's worth covering again. The EEOC is very concerned about job posting sites, whichever ones you may or may not use. So these are third-party job posting sites. You all know who they are. You post a job on there. Supposedly they have candidates and they match you. The EEOC is worried that AI may be used, and it is used, to help determine which candidates should be matched with your job. And the EEOC has a concern that the AI may inadvertently discriminate against protected classes. EEOC hasn't quite explained what all those concerns are, but that is their overarching concern. And so it's important for us to take a step back and say, we need to know the two types of discrimination, basically. It can be overt, right? I can call Anne a name or say, hey, women are too dumb to do whatever. That's overt discrimination. I have just said something negative about Anne and she's female and she's in a protected class. And I always pick on myself so I don't insult anybody else. Or, hey, Anne looks like she might be over 40. You'd be right if you guessed that. And, she's an old dog. That's overt discrimination. But you can also have discrimination based on a disparate impact analysis. So if the AI calls out a disproportionate number of applications from minorities or from women or whatever, you've got a discrimination issue there as well. It does not matter that the website, the job posting site, is controlled by a third party. The EEOC takes a position that you're still responsible for how those applications are matched, even though you have no role to play in how the AI is used or how the matches are made. And to top it off, the EEOC takes the position that they view this as an enforcement priority, which means that the cases that come through with this type of issue, they are looking at with more scrutiny. Okay, I see we have a question. Let me see if I can answer that. Okay, somebody asked, and I'm not sure I understand this, so we may have to get more information. It says, in regards to overtime, how would an employee get paid with 123 hours at 18 hours on a bi-weekly payroll cycle? So let's take a moment to break down what I think is being asked here. First of all, we don't look at a bi-weekly payroll cycle. The FLSA requires us to look at hours worked on a weekly basis. And the first rule is the employer sets the work week, which is often something like Sunday at midnight until Saturday at 11:59 p.m., something along those lines. You are free to set your work week. We look at the hours worked within that week. So they may have 123 hours total, but we need to know what that breakdown is per week. So let's say they worked 60 hours the first week. Any time that's more than 40 hours in a week is overtime. So if their regular rate of pay is $18 an hour, we multiply that by 1.5 for the 20 hours that are above the 40 hours. So it's a weekly analysis, not a biweekly analysis. You'll get yourself into trouble if you do it on a biweekly basis. So I hope I'm answering the question there. Okay, so somebody asked this. This is a great question, and I don't have an answer for it, so I'm going to disappoint here. How can an employer address potential AI job matching discrimination caused by a third-party job posting site? I don't know, because you're not in control of it. The EEOC has suggested that you have an affirmative obligation to look into how the job postings are matched to ensure that the service provider you're using is not engaging in discrimination. Now, I strongly suspect if you call up the job posting site or send them a message, they're going to be like, oh, no, we're good, we're fine. We have access to their data. You don't know who's getting turned away in the matches. I think that's a really difficult burden to put on employers, but the EEOC doesn't care about my opinion. So I feel the pain there and I feel the concern. I don't have an answer for that other than the EEOC thinks it's your duty because it is your service provider. And I do understand that to a certain extent, right? If we hired a cleaning service, it would be on us to make sure if there was a problem that we corrected it in our workplace. But I don't know how you would ever get access to the data from a third-party job posting site to know for sure that they are not discriminating. That's a really tough one. So I'm sorry I don't have a better answer for that other than to say that's a problem. Okay, so somebody said, I think California has daily. I think you mean overtime. You're correct. In some states, there are daily overtime rules. We don't have that in Pennsylvania, but absolutely, as you go out west, Colorado's another one that require overtime if a certain number of hours has been worked. Sometimes it's 8 hours, sometimes it's 10, sometimes it's 12 in a day. Sometimes it's a certain number of hours worked back to back. So if I work 10 on Monday and 10 on Tuesday, that might trigger overtime, even though I don't work a total of 40 in a week. So great point, Barb. I appreciate you taking the time to note that. Always look at state law. Pennsylvania, we have no daily overtime requirements. Other states do. Pennsylvania, we have no requirements for breaks for adults. No requirements for breaks or anything like that. But other states do have requirements that if a person works so many hours, you have to give them a break. So always be cognizant of always be cognizant of state law. Okay, one last question here, and then I'm going to go back to the slides, and I'll get any other questions at the end. It says, when you say service providers, are you referring to third-party websites that scrape the internet for job opportunities? It could be that. Or it could be, I think they're really looking for something that's more, you take a more active role in it, but I can't tell you for sure that they wouldn't look at that as a problem. What I think they're really looking for is, hey, I, the employer, send out my information and post on Indeed or Monster, or I don't even know what the hot job posting sites are these days. That's what they're really looking for. If you had no role in it at all, I don't think they would take a dim view of that, but I can't tell you that for sure because they haven't addressed that. All right, let me switch back. And then I would be happy to answer any other questions after that. So, all right. So going back to the AI just briefly here, they've issued guidance again that says employers, you gotta be watchful of this, even if it's an inadvertent and it is an enforcement priority. All right. Last but not least, the EEOC has been busy with underserved communities and low wage earners. So there was a presidential executive order issued a year or so ago to every single federal agency out there that said, you federal agency, by order of the president, must address how you're helping underserved communities and low wage earners. So the EEOC took that directive and said, here's how we're going to help. First, they've made the EEOC more flexible. It used to be if you filed a complaint with the EEOC, if I was an employee and filed a complaint, I had to go marching down to their downtown office in Pittsburgh and meet with a worker and explain my case. Now they've got video conferences, online scheduling, all sorts of things, so that if I am in a rural location or a lot of low wage earners have inflexible jobs, right? I can't just leave the fast food restaurant and go marching down to the EEOC office, that I can have different hours to meet with them and different ways to meet with them. They've also recognized that low wage earners often cannot obtain private representation. Frankly, I'm not sure I agree with that analysis. In my experience, because this is what's called a fee shifting statute for discrimination, Title VII, the employer pays the employee's attorney's fees. The employee never pays their own fees. So I'm not sure why the EEOC thinks low wage earners can't get their own private attorney representation, but that's how they view it. So the EEOC is, when we have that situation where a low wage earner can't advocate for themselves and can't get an attorney and whatever, we're going to step in and be their advocate. And that's debatable as to whether that should be the EEOC's role, because they're supposed to be an impartial fact finder as to whether or not something bad has occurred. nonetheless, that's where we are right at the moment. They're also making the EEOC more accessible for workers whose first language is not English. For those of you who, and that's probably all of you, who have different job posting requirements, notices, federal notices, state notices, if you have a significant portion of your workforce that speaks a different language, you really should be posting those in alternate languages. So something to think about. And of course, they're having education initiatives and joint initiatives with community centers and advocacy organizations in these communities to try to inform them of their rights so that folks know, hey, if all the kitchen staff is minority and all the wait staff is Caucasian, that might be an issue. So they're trying to educate these communities to say, hey, these are your rights and this is what you should look for. This is how you file a claim. This is what we'll do for you if you do file a claim. And here are some ways to do it. I'm not saying that's a bad thing. We shouldn't be discriminating against people, but we need to be aware as employers that that initiative is out there. And if we are in underserved communities or have low wage earners, they're being educated. So we should be educated as well and make sure we're not doing anything wrong in the first place. Okay, last but not least, here's my little plug for our seminar next week. So the city of Pittsburgh, if you're in Allegheny County or the city of Pittsburgh, they both have leave laws, paid leave laws that you're required to comply with. And up until this point, a lot of the compliance has just been education, right? If you messed up, the city would come in and sort of say, hey, this is what you're supposed to do. City of Pittsburgh announced last week that they're no longer doing that. They're going to have what they call strict enforcement. So we're going to talk about this next week at 11, same time, same bat channel. And we're going to talk about what that looks like, what we need to be doing, make sure we're doing it. And we'll also work through a leave example using those two regulations. So I hope you all can join us then. And I hope this was of interest and help to everybody. And I do thank everybody for attending. If you have questions, I'll hang on for a second here. Other than that, Happy New Year, everyone. Take care.